So this week in the Privacy Corner, the General Court has shut down Meta's challenge to the EDPB's consent or pay opinion. A broken cookie consent mechanism and excessive ID requirements have landed retailer Todd Snyder a $345,000 CCPA fine, and the EDPB has greenlit a short extension for the UK adequacy decision, but just this once. So first up, Meta and the EDPB. The General Court has dismissed Meta's attempt to annul an EDPB opinion on consent or pay models. This is a challenge then of EDPB Opinion 8/2024, which was adopted by the board last April at the request of several data protection authorities. So the DPAs asked the EDPB about whether large online platforms could satisfy the GDPR's consent requirements when implementing consent or pay models, as Meta has recently done, where users are asked to choose between consenting to targeted ads or paying a fee. Meta argued that this opinion was flawed and sought its annulment and compensation for alleged damages that it had caused them under Article 263 of the Treaty on the Functioning of the European Union, which allows for judicial review and annulment of certain EU acts under certain conditions. Other big tech companies such as WhatsApp and TikTok have also tried to use this mechanism recently to challenge the EDPB. So Meta asked the General Court to annul the decision, the opinion, either in part or in whole, and also claimed non-contractual liability against the EDPB. The opinion argued that large online platforms running consent or pay models should offer a subscription tier that's both free and also involves less processing of personal data. Meta said this would cause a drop in their ad revenue that the EDPB should compensate. So the court sided with the EDPB. They found that the claim for annulment was inadmissible. So the court emphasises here that the Article 263 procedure is only available against acts intended to produce binding legal effects on the complainant. The court found that the EDPB opinion did not in itself affect Meta's legal position. So DPAs should take utmost account of some EDPB opinions, namely those issued under Article 64(1) of the GDPR, but this actual opinion was issued under Article 64(2) of the GDPR, and the same requirements to take utmost account of it are not actually imposed on DPAs. So the court found that despite this annulment being unsuccessful, Meta's rights are still protected because it can challenge any subsequent actual decisions made by DPAs that incorporate this opinion. So if the Irish DPA says that Meta can't go with this consent or pay model and bases its decision on this opinion, Meta can challenge that in the Irish courts. So there is still a route of redress available to the company. They also dismissed Meta's claim for compensation, saying there was no direct causal link between the opinion and any supposed drop in ad revenue. That would be a result of Meta's own business decisions or future binding decisions by DPAs, not the opinion, which is strictly advisory. Next up, fashion retailer Todd Snyder has agreed to pay $345,178 in fines and overhaul its privacy practices to settle allegations by the California Privacy Protection Agency, or the CCPA, that Todd Snyder violated the California Consumer Privacy Act, or the CCPA. So the CPPA alleged that Todd Snyder, this is a national retailer selling men's clothes online and in stores, there are apparently 5 stores in California, failed to honour consumer opt-out requests and improperly demanded verification for certain other requests, violating key provisions of the CCPA. So Todd Snyder partly admitted to some of these allegations and kind of settled the case as a whole. For 40 days, starting in late 2023, when consumers clicked Todd Snyder's Cookie Preference Center link, the consent banner would instantaneously disappear, which made it impossible to submit opt-out requests and also meant that opt-out preference signals like the global privacy control weren't being processed by Todd Snyder. To submit CCPA requests for other purposes, so requests to access or delete personal information, for example, Todd Snyder had a special consumer privacy request portal that required consumers to give their first name, last name, email, country of residence, and a photograph of themselves holding government-issued ID. Now, this is a problem for two reasons. Firstly, you're not supposed to verify requests to opt out of the sale and sharing of personal information at all. Those should just be processed on the assumption that the consumer is who they say they are. And for the request to access and delete, etc., you do have to verify those, but you can't go too far. The CPPA found that Todd Snyder had unlawfully required government ID, whereas the CCPA requires businesses to match identifying information they already hold to identify customers or consumers and not request more information than necessary, especially sensitive data like the government IDs. So there are lots of requirements as a result of this order, along with paying the fine. Todd Snyder also has to stop requiring verification for do not sell or share requests. They have to strip down their ID requirements for other types of requests, make sure they're processing opt-out signals, and develop procedures to keep an eye on the opt-outs. They were criticised for not monitoring this portal allowing opt-out requests, and also train their personnel on CCPA requirements within 90 days. So a key reminder here to monitor your cookie consent mechanisms and make sure you're not putting unnecessary hurdles in place that effectively prevent consumers from exercising their rights, like excessive ID requirements. Big problem in the EU as well. We've had several DPA decisions on this ground asking for excessive amounts of ID. Lastly, the EDPB has given approval to a brief 6-month technical extension of the UK's adequacy decision, pushing the expiry date to December the 27th of this year. So this is another EDPB opinion, 6/2025, adopted on the 5th of May, and they are responding to the European Commission's decision to extend the UK adequacy decision in respect of the GDPR and the Law Enforcement Directive. So these decisions, of course, they allow EU organisations to export personal data to organisations in the UK without any additional contracts or safeguards, and they were adopted in it was July 2021, and the Commission put a sunset clause into these decisions, saying they will expire automatically in June 2025 unless renewed. So in March, the Commission gave an extension to that deadline by 6 months. This was because the UK is currently still tinkering around with its data protection and privacy frameworks with the Data Use and Access Bill, or DUAB, and that was introduced in October 2024, and it's still making its way through Parliament, so we haven't actually passed anything yet. The Commission wants to wait to assess the UK's essential equivalence and adequacy under a stable legal framework. So basically, once those reforms are done, if they pass, then the Commission will make its assessment then. So this is potentially controversial. Many people do not think the UK should have got adequacy in the first place. I think it was pretty inevitable that the Commission was going to grant UK adequacy, given how similar its law is to the EU's. But these reforms could change things. They're less extreme than the previous government's ideas, but they do have some controversial elements still. There's looser rules on sharing data with public authorities. There are reforms to the Information Commission's Office, and the EDPB was pretty insistent that this is a one-time thing. No other extensions should be necessary. Once this law passes, the Commission will reassess the UK's data protection framework, and we'll see what they say. I still suspect that the UK will maintain adequacy, but I have been wrong before. So watch this space. We'll keep you updated on the progress of that bill, of course. Thank you so much for your time and attention. Thank you to Privado AI for their support, as always, and I'll see you next time.